muted.
See what's in the chat box and see what we can respond to. Thank you so much for asking me to do this. Many of you know who the Advisory Council on Historic Preservation is and sort of what we do, but we have a lot of interest in how historic properties can be taken account and even improved and protected through the process of landscape scale planning. So I'm excited to be able to talk with you all a little bit about that today. As many of you know, throughout the nation, every day, the federal government is considering the effects of its undertakings on historic properties. Undertakings may be routine management activities on federal lands, but they can also be new infrastructure permitted, licensed, or otherwise approved by a federal agency. And that may occur both on federal lands as well as on state or private lands. Section 106 of the National Historic Preservation Act requires federal agencies to consider the effects of federal undertakings on historic properties. And historic properties, of course, are buildings, structures, objects, sites, and districts listed in or eligible for listing in the National Register of Historic Places. The National Historic Preservation Act also requires that federal agencies provide the Advisory Council on Historic Preservation with an opportunity to comment on such undertakings. The ACHP is an independent federal agency made up of presidential appointees, ex officio federal department and agency representatives. It is supported by a staff of 46, about half of which work directly with federal agencies and other stakeholders to ensure the requirements of Section 106 are met. The consultation process defined in the Section 106 implementing regulations at 36 CFR Part 800 and overseen by the ACHP provides a flexible framework for federal agencies to provide non-federal parties with an interest in historic preservation with an opportunity to influence federal decision-making. The Section 106 process seeks to accommodate historic preservation concerns with the needs of federal undertakings. The goal of consultation is for the federal agency, in consultation with others, to identify historic properties potentially affected by the undertaking, assess its effects, and seek ways to avoid, minimize, or mitigate any adverse effects on historic properties. At each step in the process, the agency has an opportunity to complete the process and proceed to approval and implementation of the undertaking. Of the approximately 120,000 Section 106 reviews conducted nationwide each year, only about 5% result in a finding of adverse effect and a Section 106 agreement, as described in the fourth step on this process. The unique aspect of Section 106 is that it is based on federal consultation with what we call consulting parties. The federal agency leads the consultation with the state and/or tribal historic preservation officer, federally recognized Indian tribes or Native Hawaiian organizations, representatives of local government, and any applicant for a federal permit, license, or approval. Others may request to be consulting parties. The ACHP participates in specific individual cases when warranted. The National Park Service may lead the Section 106 process for undertakings under its own jurisdiction on park lands or subject to National Park Service permits, licenses, grants, or other approvals. The Park Service, usually the keeper of the National Register of Historic Places, the Office of Preservation Technology Services, and the American Battlefield Protection Program, or other staff with special expertise, may also participate in specific individual cases when warranted. When a federal land managing agency without jurisdiction over the proposed project is concerned about its potential effects on historic properties in its stewardship, that federal agency may participate in a Section 106 review led by another federal agency, as what is described here as the other consulting party. A number of recent cases have included the Park Service participating as an other consulting party in proposals for cell towers licensed by FCC, dam relicensing by FERC, and airport layout plan approvals by FAA. I've been throwing around this word consultation. Let's look at the definition for a second. Consultation means the process of seeking, discussing, and considering the views of other participants, and where feasible, seeking agreement with them regarding matters in the Section 106 process. So we go into every Section 106 review with the hope and fervent effort to try and reach agreement about certain things that, like what is or isn't a historic property, how it may or may not be affected by an undertaking, and then what the federal agency ought to do about that in implementing the undertaking. The National Historic Preservation Act also requires that a federal agency complete its Section 106 review of an undertaking prior to the approval of the expenditure of any federal funds or prior to the issuance of any grant, license, permit, other approval for the undertaking. The Section 106 regulations add that the Section 106 review should be initiated early in project planning so that a broad range of alternatives to avoid and minimize effects to historic properties can be developed and evaluated by the federal agency in consultation with others. This is where we can start tying this in to landscape level planning. In recent years, the Park Service in particular has set the example to other federal agencies in initiating Section 106 reviews coordinated with high-level planning efforts. In 2001, for instance, those of you from Louisiana are going to have to forgive me for my pronunciation here. The Atchafalaya National Heritage Area in Louisiana approved its management plan. In consultation with the ACHP, the Louisiana State Historic Preservation, Indian tribes, and others, the Park Service found that the plan itself would not adversely affect historic properties. But nonetheless, they did a Section 106 review with this high-level planning document and came to agreement with these parties on that issue. I've clipped a little bit of a quote that was key to the ACHP's recommendations to the Park Service, that they include this statement in their record of decision about the management plan, where we describe that this is, a general management plan with a relative uncertainty of the nature of undertakings which may stem from it. The plan is essentially part of non-destructive project planning for those prospective undertakings, and therefore it doesn't define what a particular outcome might be, and therefore has no adverse effect. So, or has no effect on historic properties. And that's how we recommended that the Park Service conclude that particular review. So why would you do Section 106 with landscape level planning? It's not been all that long ago that something like that National Heritage Area plan would not have had any Section 106 with it. And I want to make clear to you all that the ACHP definitely supports and encourages federal agencies to initiate 106 with high-level planning documents. because this is the opportunity when alternatives are being developed and considered, and it's before decisions are made. So you want to front load as much historic preservation information and concerns to the process so that you don't get halfway down the road and then realize you've got major problems. So this early coordination presents the opportunity for the federal agency to identify and evaluate historic properties early, to include them in constraint mapping, and to negotiate appropriate avoidance and minimization measures like buffer zones, for instance. It's also an opportunity to build and nurture relationships with Section 106 consulting parties, which will ease future reviews, and it also can be a great opportunity to reach agreement to tailor the Section 106 review process for all of the undertakings that may result from the particular plan. Also, through such consultation, the federal agency may find that certain consulting parties may be candidates for co-management or other partnerships to ensure the protection and preservation of landscapes and other types of historic properties. So let's talk about each of these in a little more detail. It's important to initiate Section 106 early in planning because it's really the best opportunity to consult with parties and conduct landscape level surveys to identify and evaluate potential landscape level historic properties. Here we're typically talking about the general category of cultural landscapes, but we might also talking about the more specific traditional cultural properties, sometimes called TCPs, rural historic landscapes, maybe historic mining properties, and other multiple resource listings. Technical Preservation Services of the Park Service and the National Register of Historic Places have provided guidance on the identification and evaluation of these resource types. I've captured a few of them here on the screen. Because the identification and effects assessment of cultural landscapes often presents challenges in Section 106 review, the ACHP periodically offers a webinar on this topic, and so you all might want to look into opportunities to take that webinar when it is available. Just because you may not entirely know what these historic properties are, you shouldn't avoid investigating them in your planning efforts. As the old saying goes, it's not what you know, but it's what you don't know that is going to cause you problems. So we'll summarize some of those situations a little bit later on. This is also a good time to identify other known, that is already listed or determined, eligible buildings, structures, sites, objects, or districts, and include them in your constraint mapping. You know, it's hard to successfully ski the slalom course if you don't know where the slalom gates are. So you want to get those known resources onto your constraints mapping at the earliest opportunity. Once you know if any historic properties are located in the area affected by a proposed plan, then the parties may consult on what weight such knowledge should be given in designing or planning for the specific activities and projects that may result from the plan. Some questions that the parties might want to explore include what types of activities, land use, or development might be acceptable in or around historic properties. Can buffer zones around historic properties help to avoid, minimize potential adverse effects? How big should such buffer zones be? Does it need to include vegetation, or is it open space? Are topographical features like ridge lines appropriate as buffer boundaries? Other things to explore are there best management practices, or what we often in the 106 world call standard treatments, besides buffer zones, that can be appropriate measures to avoid or minimize adverse effects to the historic properties that you know about. If these are negotiated at this time, they may serve as a basis from which to streamline Section 106 review of future undertakings. One of the best advantages to high-level early consultation is the opportunity to build trusting relationships among the federal agencies and the consulting parties. At the ACHP, we often hear that agencies come to consulting parties with undertakings that are too specific and limited, such that parties feel they have an inadequate opportunity to influence federal decision-making and protect historic properties. Participation in early planning is an inoculation against such potential future concerns. It's also an opportunity to think about how the federal agency may conduct the Section 106 reviews for those undertakings later on when they're implementing the plan. Often the parties will execute a Section 106 programmatic agreement that defines a streamlined review process in which the specifics of the four-step regulatory process may be tailored. Such agreements may grant more unilateral decision-making to the federal agency, but without the trust building of participation in the planning process, parties could be reluctant to agree to that. In 2015, the Park Service, the California SHPO, and the ACHP and other consulting parties executed such a programmatic agreement for the implementation of the Merced River Plan. In 2014, the Park Service approved the Merced Wild River Comprehensive Management Plan. The Merced River watershed includes, of course, the iconic Yosemite Valley and its numerous historic properties. The Park Service was required to prepare the plan by a federal court, and previous attempts at planning had been rejected by the court because they did not adequately protect and enhance the river's wild and scenic values. Reaching a balance of natural and cultural protection and preservation was at the purpose and need for the plan. The plan forecasts a vast array of potential undertakings. So the Park Service was very interested to streamline the review of the future undertakings with the consulting parties. A Section 106 programmatic agreement among those parties was executed prior to the record of decision for the plan. Initiating Section 106 early in landscape level planning is also a great opportunity for federal agencies to identify candidates for co-management or other types of partners. We have here at the ACHP have experience where consulting parties have ended up as site stewards. They've ended up leasing or having some other kind of agreement where they use or maintain or repair or even rehabilitate historic property. Some of these groups are able to raise funds to support historic preservation as well as other landscape conservation initiatives. There may be other volunteer type opportunities that these folks might want to participate in. And it's a great way to share expertise. A lot of federal agencies have a lot of very expert people, but there are others out there too that can really open our eyes and provide us with knowledge that we wouldn't have otherwise. Well, after considering all of those advantages to initiating the 106 process early, I want to take a diversion and kind of illustrate for you what can happen when that level of planning and coordination with Section 106 review and the preservation of historic properties. When it doesn't happen early in planning, it can cause a lot of trouble. And I really have a nightmare scenario to share with you all. Some of you may be aware that the Advisory Council on Historic Preservation, the actual membership of the council, again, we're talking about the presidential appointees and other high-level agency folks, provided formal written comments to the Departments of Agriculture and Interior regarding proposed oil and gas development in the Lewis and Clark National Forests in Montana. This map isn't a particularly great map, but north of the site is Glacier National Park, and south of the site is the Bob Marshall Wilderness. The high country parcel proposed for development is located immediately south of Glacier National Park. So you see there's a little water body over on the left midfield of the picture here, and there's a road going there. On the left and top of the page is Glacier National Park, and then the development site here is in the foreground. This case has a very long and convoluted timeline, which I'll try to briefly summarize. It was the Bureau of Land Management's decision to grant the oil and gas lease in this location in 1982, prior to and without any environmental or Section 106 review. And it was that decision that set this course in motion. In this regard, it is a worst-case scenario illustrating the potential for delay and legal challenge when historic properties are not considered early in project planning and prior to the approval of an undertaking. In 1982, BLM issued a whole bunch of leases. So you've got some pink boxes here. The blue box is the subject lease that ended up in this particular case. Again, this also shows you that the Bob Marshall Wilderness Complex is just immediately south of this area, and Glacier National Park is immediately to the north and west. The Continental Divide runs right through here, so I know this is one of your geographic areas that in the Scaling Up initiative you're particularly interested in, so some of you may be familiar with this area. Through 5 ethnographic studies, they were able to identify the Badger 2 Medicine Traditional Cultural District. In 2 decisions, the keeper of the National Register of Historic Places determined that an approximately 150 square mile district was eligible for listing on the National Register. The red boundary here on this map illustrates that full and current extent. The vast majority of the district is located on National Forest lands, but a small area is located on the Blackfeet Indian Reservation. From the time the lease was granted in 1982, the Blackfeet Nation expressed their concern that the proposed oil and gas development would be located in an area that they considered historic and sacred. These early concerns led to the preparation of an environmental assessment, resulting in a finding of no significant impact and decision to approve an application to drill. The tribe filed objections, which were to be addressed in a second round of environmental impact statements in 1991. It is important to note that the cultural landscapes, and specifically the traditional cultural properties, have always had the potential to be eligible for the National Register. But it wasn't until the 1990 when the Keeper published Bulletin 38 and 1992 when the National Historic Preservation Act was enacted that we specifically came to understand that such properties could be eligible and therefore require consideration in the Section 106 review process. The tribe challenged the 1991 approval of the permit to drill in federal court, and the agencies were remanded to complete the Section 106 process. The Forest Service and the tribe worked together to identify that 150 square mile historic district. As this undertaking was evolving, the Forest Service decided to institute a moratorium on new mineral leases in this area. And by 1997, the area was formally and permanently withdrawn from minerals leasing. Congress then passed legislation providing tax benefits to existing leaseholders in that area if they would transfer those leaseholds to nonprofit conservation organizations or back to the federal government. The great majority of those leaseholders did take advantage of that incentive. But the blue box, the Solonex lease, they decided to continue to press for their right to exploratory drilling in their leasehold, resulting in the Section 106 review, which began in 2014. The lessee objected to the determination of eligibility for the district, despite the 2002 and 2014 keepers decisions, which are final and not appealable. The lessee objected to the finding of adverse effect and any proposed measures to avoid, minimize, or mitigate such adverse effects. Ultimately, the Blackfeet Tribal Historic Preservation Officer terminated consultation, and the rare formal process for the membership of the ACHP to provide written comments began. The council comments stated that this district is of such unique significance and integrity that the type of adverse effects expected from oil and gas development should be completely avoided by cancellation of the lease. The Secretary of Agriculture concurred with the council comments and asked the Secretary of Interior to cancel the lease. In Interior's response to litigation by the lessee, it did cancel the lease in early 2016. The lessee continues to challenge this cancellation in federal court. It's difficult to summarize 30-plus years of study and court challenges in this setting. Again, for the ACHP, that entire 30-year process began with the federal agency granting the leases without a prior understanding of whether historic properties may be affected by the proposed oil and gas development. BLM and Forest Service have learned a lot since 1982. It is now more routine to conduct planning and environmental reviews prior to leasing mineral rights and other permitting, licensing, and approvals. It's also important to note that adverse effects to a historic property are not necessarily deal breakers for proposals. In approximately 5% of the annual Section 106 reviews, federal agencies and others execute Section 106 agreement documents that document the consultation and the agreed to measures to avoid, minimize, or mitigate adverse effects to historic properties. With such an agreement, the Section 106 review is complete and the agency may proceed to approval and implementation. In a more positive example, the Bureau of Land Management has been coordinating Section 106 reviews with its landscape level planning for the development of renewable energy generation facilities on federal lands. BLM approved its solar energy development in 6 southwestern states in 2012. The states included are Arizona, California, Colorado, Nevada, New Mexico, and Utah. In its solar plan, the BLM has categorized lands that are excluded from utility-scale solar energy development and has identified specific locations that are well-suited for utility-scale production of solar energy. They call those the solar energy zones, or SEZs. The program emphasizes and incentivizes development within the SEZs and outlines a collaborative process for identifying additional SEZs. The program allows for responsible utility-scale solar development also in variance areas, but they have to go through a special process. A Section 106 programmatic agreement was executed prior to the final programmatic EIS and record of decision for this very large program. Also, the Desert Renewable Energy Conservation Plan will help provide effective protection and conservation of desert ecosystems while allowing the appropriate development of renewable energy projects. In this plan, it addresses 22.5 million acres in the desert regions of 7 California counties. It is an innovative landscape-level plan that streamlines renewable energy development while conserving unique and valuable desert ecosystems. This is a collaborative effort between the California Energy Commission, the California Department of Fish and Wildlife, the Bureau of Land Management, and the U.S. Fish and Wildlife Service, also known as the Renewable Energy Action Team. In just a few days ago, September 14th, 2016, BLM signed its record of decision approving the application of the plan to the 10 million acres of BLM managed lands. In it, the BLM designates preferred development zones and conservation zones. Other areas may be developed, but will require additional review. Again, they initiated Section 106, they took historic properties into account, and then they negotiated a programmatic agreement for this plan that will streamline and tailor the Section 106 review of projects under the plan in the future. In summary, the ACHP encourages federal agencies to conduct landscape-level planning and to initiate Section 106 reviews early in such planning, while alternatives are being developed and considered and prior to the approval of such plans. Such coordination presents the opportunity to identify and evaluate historic properties early, include them in constraint mapping, and negotiate appropriate avoidance and minimization measures like buffer zones. It's also an opportunity to build and nurture relationships with Section 106 consulting parties, which will ease future reviews and may be an opportunity to reach agreement to tailor the Section 106 review process for the undertakings that arise from the plan. Also, through such consultation, the federal agency may find that certain consulting parties may be candidates for co-management or other partnerships to ensure the protection and preservation of landscapes that are also historic properties. Experience has shown that when agencies coordinate Section 106, NEPA, and other planning processes, the agency has better information from which to make a decision. The knowledge of whether historic properties are present and may be affected prior to the selection of a planning alternative is a key to defensible and timely decision-making. It is in the interest of the agencies, applicants for permits, licenses, and other approvals, and preservation advocates to air historic preservation concerns early in project planning so alternatives to avoid adverse effects to historic properties may be fully developed and considered along with other environmental concerns. Your role in encouraging and ensuring Section 106 is incorporated into landscape-level planning efforts is critical to improving preservation outcomes in federal undertakings. Well, y'all have been not chatting on chat, so I'm interested to hear what you all have to think about this, and I'm happy to address any questions if folks have them.
Great, thank you again.
Thank you so much for...
Yeah, go ahead, Katry.
Oh, I was just going to say thank you so much for allowing me to speak with you today.
Oh, thank you. That was incredible. Incredibly informative. Okay, let's open it up for Q&A. Again, folks, feel free to use the chat box, enter your questions there, or go ahead and ask a question over the phone now.
Hey, this is Laura, and I did send a chat at 10:25, and it apparently never showed up in your box, so there may be other chats. So I would thank you so much. The story in the forest is most interesting, and my main question from that is, who sponsored the ethnographic studies that eventually established the TCP?
Yeah, they were all paid for by the Forest Service. By that time, BLM and Forest Service had developed a working relationship that when oil and gas development was going to occur on Forest Service lands, they would take the lead in the Section 106 reviews, and so so they bankrolled it. Now they used contractors, and sometimes they actually contracted with the Blackfeet Nation, and then the Blackfeet Nation chose particular contractors. So there was a couple of different ways it was done, but it was all Forest Service led.
That's very interesting because we invariably recommend ethnographic studies and we invariably hear that it's much too expensive. Do you know if the Forest Service had some money, or if they did cost recovery and recovered those costs from the applicants, or how this was different than the climate we have nowadays?
I'm afraid I do not know that, but I might be able to put folks in touch with the forest, and I'm sure they'd be happy to share some of that information if they. Of course, there were so many changes in personnel over the years; they might not all know about all of it. Some of that might have been lost in a 30-year history, but you might be able to get some background on that.
That would be, yeah, it would be terrific because we would surely like to see a lot more of this, but we normally get stopped at the stage of people saying, well, nobody can possibly afford to do that. So thanks.
Well, and that's the other thing. There was no reason why they needed to do 5 studies in order to get to this. If the first 1 or 2 had been done in a way that the tribe was also amenable to, they probably wouldn't have got to the 3rd or the 4th. And by the 3rd or the 4th, the main issue there was how big is this place, and just really dealing with, you know, what is the boundary? Put a boundary on something that really doesn't have a boundary in terms of the tribal perspective. So that became, you know, the real focus of the later studies.
Nice, thank you.
All right, Katry, we've got a question here in the chat box from John Putnam. Given the political sensitivity in the U.S. of the buffer zone concept, can you please provide some examples where this has been used successfully?
Yeah, well, you know, the buffer zone is a best management practice that can really make things a lot simpler for federal agencies and non-federal parties that are trying to further certain goals, not unlike an oil and gas developer or some other renewable energy developer. But so provides predictability from that management standpoint. But it's really hard when you're trying to protect a resource to try and put your finger on, you know, well, how big does it need to be? Does it need to be made up of trees or bushes or what, or is just open space enough? You know, all of those kinds of things are really important questions to ask. And with historic properties, the issue becomes what is actually part of the setting of the historic property and therefore should be included in its boundary as a historic property versus what is that edge that might not be in the historic property but makes a difference in terms of whether or not it's affected. I don't know if that answered the question or not, but
Great.
I guess the other thing I would say is in the various consultations I've been in, I've not seen a political incorrect knee-jerk reaction to the concept of buffer zones. I've seen people wrestle with those issues quite a bit, but not dismiss them wholesale.
And I would suspect that makes it different if it's a NHL involved, right?
Well, not all historic properties are created equal, you know, and one of the ways we know that certain historic properties we really need to sharpen our pencils and do the best job we can to avoid direct adverse effects. One of those types of properties are NHLs. That's one way we recognize, okay, this property needs to have more protection. The Badger 2 Medicine situation was not an NHL, but the membership of the ACH Peace Panel found the testimony of the tribal representatives, and then just individuals who happened to be members of the tribe, was all very compelling, that this place was, for lack of a better word, their Garden of Eden. This is where the world began. This is where, everything that their higher power gave to them is there. And that level of significance was very compelling for our membership, and weighed in on our recommendation to ultimately cancel that lease. Is because, not only did you have this procedural flaw, but the potential to really affect this very important resource needed to be reevaluated.
Any other questions? Well, I've got one for the East and West, where there's national heritage areas that have been designated, mm-hmm. and there's a federal action and undertaking. How does that, you gave the example of the NHA in Louisiana, how does that generally, how is that handled with the advisory council? I mean, because the heritage areas, of course, some are so much more sophisticated than others, in terms of having, different information and cultural resource studies, available. I'm thinking like the Gullah Geechee, maybe they're a little bit more advanced than some. How do you all handle that or approach that?
Well, the ACHP, being, a team of 46 staff, and some presidential appointees, we don't make it our business to go out and, tell these different entities that, oh, you need to be doing 106 and this is what you need to be doing. But we're generally in a reactive mode. So when the National Heritage Area in Louisiana came forward to us and said, hey, we're doing a Section 106 review, and we've used the NEPA process to substitute for Section 106 documentation. Here's our NEPA document. We reviewed it, and when we reviewed it, we had some suggestions about how to finesse the language and whatnot. But the basic concept was that they had actually, met with folks and talked about the plan and gotten people on board, right from the beginning. And I guess that's, if we were to make a recommendation, to these groups, is just to get started. You don't know which step in the process you're going to be able to finish at. You might be able to, it might not be that much of a discussion, but at least tell people that you want to talk about it with them, give them the opportunity to weigh in. And I think in those heritage areas, and it's even more important there because there's so many different people with a stated interest in historic preservation that you've just got to bring them to the table and find out what they think about it.
Great. All right, any last questions? All right, well, let's end it there. Thank you so much, Katry, for your time and all the work that you put into your great presentation. Really appreciate it.
I'm sorry we ran a little bit over. I hope folks found it interesting, and thank you so much again for giving me this opportunity.
Yeah, thank you again. This webinar will be posted at some point soon on our toolbox, and then also hopefully our external page on the Practitioners Network for Large Landscape Conservation. Also, our next webinar will be October 24, and it's on the Y2Y Conservation Initiative. Jody Hilty, the president of Y2Y, will be our presenter. That's an amazing large landscape conservation effort. And then on November 16, Heather Engelston with the Park Service will be discussing NNLs, National Natural Landmarks. So make sure you listen in on that for that webinar as well. All right, thanks a lot, everyone, for joining. Have a great week.
Thanks for doing it.